It's nice when certain opinions one of us has is supported later by empirical data in the form of a study which comes out and adds some objective evidence to opinions which we've believed in and had for a number of times. And that's the subject of today's video, because one of the opinions which lawyers express to their clients is the importance of settling a case. Litigation is costly and it's highly risky, and one of the risks deals with the individual proclivities of the judge who happens to be hearing the case. In family law, there is a wide range of discretion for most issues. There's very few things in which judges are told, you absolutely have to do this and you can't do anything else. Rather, most issues involve range of discretion, and as long as the court stays within that range of discretion, the court will be affirmed on appeal. And therefore, when we go into litigation, sometimes we're not sure where that judge's opinions and philosophies and practices fall within that range of discretion, and there's a great deal of risk to the individual client. So one of the things lawyers typically explain to our clients is that one of the reasons we're recommending making the compromises necessary to settle a case is to avoid the risks not only of anything else that can go wrong at trial, but of the judge's opinions, feelings, and, here's the tough one, the mood of the judge on any particular day. Here's my outrageous statement for the day. Judges are human. Wow, that's going a long way, huh? And as human beings, they're affected by all of the normal stuff us human beings go to, including having good days or having bad days. So one of the things that we'll typically tell our clients, good lawyers at least, is when you go to trial, when you litigate this, you're taking the risk at the mood of a particular judge on a day. Could be good, could be bad, but we don't know that in advance. So where am I going with all this? Well, it's that's one opinion, and I think well supported by anecdotal evidence. But now I have some science for it. There is a wonderful study done which proves the point in a mathematical and objective sense. It was done by two professors at LSU, and it came out a few months ago. And what they did is they looked at juvenile dispositions for certain cases, controlling for as many issues as they could. They controlled for the type of offense, they controlled for race, genders of the defendants, and they were studying the dispositions that the court would order when the court had a potential range of dispositions. In other words, these aren't mandatory sentences, but the judges could sentence based upon how they felt about the individual circumstances within a certain range. And the point the study was looking at was not anything that had to do with the particular defendant or the particular charge, but with how the LSU Tiger football team did on the previous Saturday. If anybody's familiar with LSU, football down there is a form of religion and is held to a very, very high degree of importance by people down there, and apparently by the judges as well. And what the study looked at was a total of 8,200 cases decided by a total of 207 judges. And what they looked at is what happened if LSU failed to meet expectations from the previous Saturday. In particular, if LSU was predicted to win or if LSU was predicted to lose, and would it make effect on juvenile dispositions with the theory that if they're looking at enough cases, would there be a statistical difference? And the answer was yes, there was. First, if the judge was not an LSU graduate, then it didn't make any difference. The sentences were the same regardless of how LSU performed. If the judge was an LSU graduate and LSU won by as much or more than what the point spread was, the sentences didn't make any difference. It didn't make any statistical there was no statistical variation in terms of the sentence. However, and here's the key, if LSU was predicted to win by 4 points or more and ended up losing, and the judge was an LSU graduate, there was an average increase in disposition lengths ranging from 46 to 74 days based upon the individual defendant. And the researchers couldn't find any other statistical correlation to account for it other than the fact that that particular judge was an LSU graduate and I guess wasn't happy by the performance of LSU the previous Saturday. It's a great study. It's a lot of fun to read about. It was reported in the ABA Journal last September. It's available online if you go to aba.net and take a look at the story in more detail. But my point in it is how it reflects in family law, because the issues, as I said, are very, very highly discretionary in most instances. And judges have their own individual proclivities. Some of them feel more strongly than others about both parties working and maximizing income ability. Some are more likely to share income equally in support than other ones are. And all judges, as I said, outrageous statement of the day, are human beings and may be affected not only by their own experiences, but by their particular moods on a particular day. I remember a number of years ago having a case in which I thought a very good judge made a very bad ruling. And with my heart in my mouth, I brought a motion for reconsideration, something I rarely do because they're like never successful. But it was a really, really good judge who I had a lot of respect for and a really surprising ruling. We went back to court, and the other side was all geared up to ask for costs because I really had no other arguments. And before the hearing started, the judge said, before I hear any arguments from anyone, I want to make some comments on the record. He said, the morning this case came up before me, I got up and I wasn't feeling well. I should have called in sick. Instead, I decided to see if I could make it through the day. I was feeling worse and worse as the day came on. And obviously, my decision in this case is indicative of the fact that I wasn't performing at full capacity that day, and therefore I'm going to vacate my prior order and start over again. I truly respected a judge who admits making a mistake and does the right thing about it. But the point is on the original date, he wasn't feeling well. He's human, and he made a mistake just like all of us make mistakes. The point of this video today is to try to continue to impress the importance of reaching resolutions and settlement. I preach on this a lot. I write on it a lot. I've written a whole book on settlement negotiations for the ABA. And one of the things we tell clients is that reaching a settlement avoids having to worry about the individual proclivities of the judge, the individual opinions of the judge, or the particular mood of the judge on an individual day. In order to get there, however, settlement requires compromise. And the reason this sort of speech needs to be given to clients is compromise means giving something up. Compromise does not mean getting everything you want. If you want to try to get everything you want, then go to trial. Maybe you'll hit a home run, maybe you'll hit a grand slam, and maybe you'll strike out. But you're not going to get that home run or grand slam through a settlement. At a settlement, if you're lucky, you get a triple, more likely a double. Sometimes you're lucky to hit a single. And the reason is in order to get to the settlement, you have to give things up, and hopefully the other side gives things up, and even more hopefully, what both sides give up are things of lesser importance to them, things that they can live without. This type of recognition needs to be given to the client at the initial settlement discussion between the lawyer and the client before even entering into settlement negotiations. And part of the reasons we give, of course, is the incredible cost of trial. which includes post-judgment motions to reconsider sometimes even appeals, but also in terms of the risks. And the risks include those of judges making bad decisions because they're simply human beings. So take a look at the survey. If you Google LSU and juvenile dispositions, you're going to find a number of different links to it and discussing the study, and it's a nice handy tool to illustrate to clients an objective framework for why, when we say judges are human and react humanly, that clients will understand and appreciate.